Good morning, everybody. Happy Wednesday morning, and we appreciate your joining us for Jim Reedy's Employment Law Year in Review. We do have a slight delay this morning. Jim is here, but he needs just a few minutes extra before he can jump in and do his presentation. So we appreciate your being here and just hanging with us for a few minutes. It's 8:05. I suspect that, just 2 or 3 minutes he'll be here with us and we'll kick things off. And it gives our other attendees a few minutes to join. So we appreciate your patience. I will still be here. I'm Liz Tezick. I'm lurking in the background. So if you guys need anything, shoot me a question in the Q&A and I can answer anything, but we should get started here any minute now. Thank you.
Well, good morning, folks. Hope all are doing well. This is the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy, coming to you from Sheehan Finney. This is our monthly event. Today we're going to be talking about the Employment Law A Year in Review. It's like the record albums from years ago, greatest hits so far. We're just in June of 2025, and obviously we got more about a half of the year to go. But we usually do this at the end of the program year for purposes of the Tech Alliance HR Exchange, just as we go into the summer months before we resume our program again in September. We sort of look back over the last year, and in particular, the last several months, to review where we are for purposes of labor and employment law. So thank you for joining us this morning. And a couple of housekeeping matters. This is a SHRM HR certified program. Liz Tezick, at the conclusion of the program, you'll actually see the slide, but also the SHRM codes will be sent to you in an email with a link to this program along with a copy of the materials. And again, that will be sent to you automatically, but you'll see the codes at the conclusion of this program. So I'm thrilled that we're here. It's amazing that we're in June, even though the weather today doesn't feel like it. There's a lot going on, and I'm stating the obvious for purposes of labor and employment law, or just things in the world. But let's get going. And the questions, if you have them, you can type them into the question Q&A section in your materials, and I'd be happy to answer them to the extent I can. But let's get going. So first up is, as I click on here so I can advance my slides, there we go. Over the last year, and especially the last 6 months, there have been several significant changes with regard to workplace laws and regulations. And whether you're just here in New Hampshire or you're in New Hampshire and you've got operations in other states, you certainly know that's true. And whether it's you're talking about federal law and or state law, there have been many changes that have happened in the last year that impact your job as an HR professional, that impact your workplace, and impact your employees. And yes, buckle up, because it's like those Ronco commercials. Just when you thought there was enough, wait, there's still more. There's always going to be more with regard to workplace laws and regulations. But what we're going to cover today is we're going to talk about one thing that perhaps is giving you still a bit of PTSD is the changes to federal overtime regulations in the last several months. That was in November of 24. Update on minimum wage laws, the apparent flip-flop with regard to independent contractor rule from the feds, pay transparency and pay equity laws, the U.S. Supreme Court cases and decisions, federal and state enforcement actions and trends, meaning we're talking about typically the Department of Labor. We can also be talking about our friends at EEOC, some hot button issues and some compliance reminders this year, and breaking news with regard to non-compete case in Massachusetts that just broke last week, and what could be on the horizon. So there's a lot to talk about the time that we have, but again, if you have questions, you can reach out to me in the Q&A, or you can reach out to me afterwards. Well, let's start first with our that November surprise, the FLSA overtime exemption reversal, or like what we refer to it as Back to the Future. So as you may recall, that in April of 24, the U.S. Department of Labor proposed a two-tier increase to the salary threshold for the white-collar exemptions. The ones we're talking about, typically they refer to them as executive, professional, and administrative, but there are also others, the highly compensated computer professionals, outside sales, and so on. So in July of last year, we prepared. Now, remember, it wasn't that long ago that there was a block, a last-minute block to the last time during the Obama administration sought to increase the salary threshold for overtime exempt employees. Remember, the combination for the overtime exemption is paid on a salary basis over the threshold dollar amount, and the employee's actual job performance fits within one of the categories of the white collar exemption and satisfies all the elements of that category. So again, April of 24, DOL proposes, okay, we're going to finally increase the $684 a week to, in July, $844 per week. And then in January of 2025, January 1, increasing yet again from $844 to $1,128 per week. So you look about, it's nearly a doubling of the amount from pre-July of 24 to post-January of 25. And there were some legal challenges. And of course, we had a hotly contested election last year. And what happened? Well, a court in Texas basically blocked and we've seen a lot of these national injunctions, blocked not only the January implementation of the second tier, but rolled back the July increase. And so that sent a lot of people, a lot of HR professionals scrambling. And throughout our discussions with HR professionals, many, of course, already paid above the current threshold, as well as potentially the proposed threshold. And very few rolled their salaries back to the pre-July 2024 salary threshold. So the most important part there is the duties test. The duties test did not change, and those are the elements of each of the exemptions, the required duties in order to be exempt, again, along with being paid on a salary basis above the threshold. The Department of Labor did appeal the injunction, but then in April of this year paused its appeal. So it's in a sort of a netherworld. If you're a betting person, I would say I would not assume that you're going to see another increase this year or next with regard to the salary amount, unless Congress does something in that regard. But the focus should always be, assuming the salary part is satisfied, focus on the duties. And the duties, meaning that not just what is written in the job description, but how the person actually performs the job on a day-to-day basis, because that's truly what will be determined as to whether or not the person is fitting within that overtime exemption. Minimum wage laws, well, we know that many states, 20 states and several cities increased their minimum wages in 2024 and 2025. They range from $7.25 here in New Hampshire to as much as $20 per hour for fast food workers in California. And other states are hovering between $12 and $15 per hour. And then, yes, the federal minimum wage is still stuck at $7.25, and that is unlikely to change. It has not changed since 2009, and we will likely not see that change anytime soon. And another change that we saw, and again, what's the concept? The concept is that elections have consequences. Well, that is absolutely true. Whether we're talking about the National Labor Relations Board or EEOC or the Department of Labor, with those changes in the White House, likely you will see changes in some of the federal executive agencies and some of the independent agencies as well that have federal appointments from the president. The independent contractor rule. So that is another back to the future. So during the Obama administration and even during the Bush administration, there was a standard for purposes of independent contractors. During the first Trump administration, that flipped to a more employer-friendly contractor standard. In part, that was due to COVID, but in part, that was also a tip of the cap to business. The Biden administration reverted back to the pre-Trump era, which was basically, again, the Obama and Bush era standard. And surprise, surprise, in May of this year, the USDOL directed its investigators not to apply the 2024 standard, which was the Biden era standard. And so where are we left? Well, the standard is still there. It's not being enforced right now. I think the thing to mention in that regard is independent contractor tests. You've got many. It's the IRS rule, the State Department of Labor with regard to wage and hour, the State Department of Labor with regard to workers' comp. You've got the EEOC standard. You've got the common law standard. And of course, you've got the USDOL standard. And just because you satisfy one of those other standards, add one more to the mix for unemployment under state unemployment law. That's yet another standard. And just because you satisfy one of those doesn't mean that you've satisfied all of those. So where are we? On the federal level, where we are is this test, which again has been paused and it's under review right now. But all of these tests basically have one common element, and that is the direction and control. Does the employing entity, whatever that it is, if it's a contractor and still you have an entity that is engaged in the contractual arrangement, does that entity control the way in which the person performs the job? I had a plumber come to my house on Monday, and all I needed was, because I live in an area where there's a high water table, I needed my sump pump updated, and I didn't tell him how to install it. All I said was, this is what I need, and I need it done. And they provided me with assurances that it was done, and we agreed upon a price and so on. So did I control what they did? The only thing I did was I said, this is what I need and when I need it and what it's supposed to do. And that was the extent of it. That's an arm's length transaction. But the test, let's go through that because it's kind of important, because more and more as you're dealing with a lot of the economic pressures out there, you may get a call from the C-suite saying, look, we can't take any more on the headcount for regular employees, but you know what? I've got this needs to be done, and can we have that done? Or we've done a RIF recently, and when I bring somebody back, can we bring them back as a contractor? Or the person prefers to be a contractor. None of those things are controlling. What controls is the test. And that would be, one, the opportunity for profit or loss depending upon on managerial skill. What are we talking about there? The individual. Does he or she have the opportunity for profit or loss depending upon the work that they're performing? Is there risk as well? The investments by the worker versus the employer. What are we talking about there? Materials and supplies largely. and for purposes of the engaging in the activity. The degree of permanence of the work relationship. If you've got an independent contractor that you're working with for more than a year, more than 2 years or more, then I think you may have a situation where the person may be sufficiently integrated that is deemed to be an employee, and that would depend upon how much time they spend in the office, the integration with other employees, and so on. Again, going back to the nature and degree of control of their work, are you fly specking everything? Are you looking over their shoulder? Are they having to produce daily reports and so on? Those are more attributes of employment. And to the extent that the work is integral to the employer's business, in other words, does that contractor do what you do, meaning the nature of your business? If it's not, meaning it's something that your operation typically does not do, you don't have the capacity or the to do the work, then yeah, it could be a contractor relationship. But if it is something that effectively replacing another employee or a function that was otherwise done by employees, you may have attributes of employment. And then skill or initiative required for the work. No single factor is a determinative. It's a totality of the circumstances test. That's a good and decent test. It's not that different from what was before. Before was more lenient towards finding someone as an independent contractor. I think the thing to take away from this is this. Under the law, whether we're talking about state or federal, there's a default, an assumption that someone is an employee rather than a contractor. And you must overcome that presumption with satisfying whatever the applicable test is. So proceed with caution. Another important development from the last year was the executive orders from the president talking about DEI. And that came out in a number of different ways, whether or not declaration that there are two genders, to specifically saying an executive order regarding diversity, equity, and inclusion, and saying we're removing those from federal agencies, those programs from federal agencies and the funding for those, as well as if you are a federal contractor, you must do away with those programs and shift from effectively preference in hiring, promotions, training, and development to a merit-based system, something that employers do anyway. Elimination or scaling back of DEI programs, requiring federal contractors to actually certify. They do not operate, and the term is, do not operate an illegal DEI program. Of course, there is, that was lacking in some definition as to what is an illegal DEI program. But the risk is high, and the risk is high because under the Federal False Claims Act, if there's a certification that an employer or a federal agency or a federal contractor does not have an illegal DEI program, when in fact it's found out that the contractor does, then there are substantial penalties that could attach to that workplace, something to avoid. And also, we're going to talk about this in a second, but after the Ames case, the Supreme Court case involving the city of Sanford, Florida, there's the potential for finding of reverse discrimination when there's a hiring preference that is not tied to an affirmative action program, which also had its legs cut out from underneath it with a Supreme Court case involving universities. But this is basically a fallout from actually two executive orders from the White House in this new term, in this new presidency. When asked about this, a lot of HR professionals are asking, well, what do we do now? Well, my response is, you can do what you've always done, which is hopefully you're an equal opportunity employer. You don't discriminate on the basis of any of the protected characteristics: age, race, gender, color, religion, disability, national origin, et cetera, et cetera, et cetera. To the extent that you are looking at your workplace and trying to work on succession plan, look in areas that needed more bench strength and so on, and to the extent that you are trying to make your workplace more representative of and attach more to the communities in which you work, there's no problem in that regard. It's just that when you have very specific DEI programs, again, if you're a federal contractor, proceed with great caution. Can you effectively rename it something else? Yes, but just be careful. I think that the way to stay with this really is be an equal opportunity employer, abide by applicable state and federal laws. And again, those, especially with state laws, can vary from state to state. Pay transparency. Well, the fate of EEO2, that is stalled. That was one that got to gender and wage information and providing wage information to the feds. That has been stalled for some time, and that's not coming back anytime soon. However, in the meantime, 29 states in the US have pay transparency and disclosure laws. And basically it's just with regard to providing information on wages, wage ranges and so on, but also like in New Hampshire, you can't penalize employees for discussing wages and so on. So some laws make it illegal for an employer to ask an applicant or new employee what they're making in their previous job, provide salary information. Why? Well, because that would be a way of basically saying, well, I understand you're making X with your current employer. We'll pay you X plus 5, as opposed to disclosing what the wage range is for that position. Again, New Hampshire's pay transparency law, in a nutshell, is basically requires open sharing of information about employee compensation, salary ranges, pay structures, and sometimes individual salaries. Who cannot share that information under New Hampshire law? HR professionals. For those tipped employers out there, there was you've got the federal tip credit that returns to the pre-2021 dual jobs regulation. In New Hampshire, there was we had a change with regard to, in the last year, with regard to tip pools, tip sharing, and service charges, a clarification of the law that was a bit wonky in how it was applied. Now it's more straightforward with regard to whether similarly situated tipped employees can pool their tips in a voluntary tip pooling system, or tip sharing between tipped employees and non-tipped employees, again, a voluntary system. And what is interesting and perhaps sort of emblematic of what we're seeing with some of these laws or tinkering with tip systems is what we saw in DC in 2022 that passed an initiative in the city itself that gradually eliminated tips by increasing base wages, the hourly wage rate. But what DC was experiencing was restaurants were closing because they couldn't find help. The tip wages effectively were eliminated. And so now DC is talking about rolling back and repealing that initiative. The curious part about that, just very quickly on this topic, is when you go to a coffee shop, when you go to get a sandwich somewhere, the flipping of the screen, which is a phenomena largely of COVID, where you're asked to tip and they give you designated amounts or something other or nothing. The question there is, who gets the tip? If you're ordering a sandwich and you order it over on this counter and then the cashier flips the screen for you, does the cashier get the tip? Does the person who took the order? Does the person who prepared the sandwich? And so on. The same is true with a cup of coffee and so on. And the answer is the Department of Labor has not addressed that. New Hampshire Department of Labor has not addressed that yet. And it's on a case-by-case basis. But that's a very interesting one as to whether or not, because a tip is directly from the customer to the person providing the service. But if there are several people providing the service, the question is who gets the tip and can it be shared and so on. So that is an unresolved issue that our friends at Labor will be, we understand, are looking at and will be addressing in either a statutory change or regulatory change. Some Supreme Court cases from the last year. And again, we're in June, so we've got a few cases that we're waiting for the department the court to finally issue its decisions. that those will be out anytime this month or early in July. And then the court will be not be in session again until that first week in October. So the first case, which was decided in January of this year, was the EMD Sales versus Carrera case. And that was the question of what is the burden of proof that employers need to show to support their Fair Labor Standards Act overtime exemption decision. Is it a preponderance of the evidence or clear and convincing proof? Clear and convincing proof, of course, being the higher standard. And the court said, no, preponderance of evidence is fine, which is basically 51%. Now, obviously, you want to have a clearer decision than that, so it's not too close to the edge. But that was a positive decision for employers. The Ames versus Ohio Department of Youth Services was just recently decided. That's the one I referred to before when we were talking about DEI. That was a unanimous decision by the Supreme Court, and Justice Jackson is the one that delivered the majority opinion on that. There were two concurrent decisions, I think Gorsuch and Thomas, but it was a majority decision. I'm sorry, a unanimous decision. And basically it says that there could be a situation where for purposes of the standard, it's a reverse discrimination case, but basically it was a heterosexual female who basically claimed that she was discriminated against in hiring and advancement in her workplace based upon her sexual orientation. And the question before the court was, because effectively this Caucasian female heterosexual is deemed to be in a majority group, does she need to show enhanced background circumstances in order to prevail on the claim? And the court said no. The Title VII, the Civil Rights Act of 1964, as amended in 1991, the standard that was of showing enhanced background circumstances was not consistent with the law. So it goes back to a standard of proof, generally speaking, for employment discrimination cases. And one case that is pending is the Stanley versus City of Sanford case. I mixed the cases up a few minutes ago with regard to Ames and City of Sanford, but Ames is versus Ohio Department of Youth Services. The Stanley case is the City of Sanford case, and that's an ADA case. And that's pretty interesting. That was a person who was a former employee of the city, and I think it was in the fire department, who was out on disability insurance, disability plan, disabled during employment, but post-employment, the person is no longer employed there. The city is changing its policy with regard to disability benefits, which could have an adverse impact upon Stanley, the former employee. And the question is whether or not Stanley could proceed with an ADA claim, even though Stanley was no longer employed by the city at that point. And so that has yet to be issued, but we're expecting that any day now. Federal enforcement efforts, we're seeing a lot. I'm actually in the middle of 3 U.S. Department of Labor audits right now, and the State Department of Labor has been active as well. With regard to the state, inspectors from issued in 2024, fiscal 24, 963 on-site inspections with employers. And again, we're back to on-site in the post-COVID era. Over $1 million in civil penalties and wage adjustments were collected by the department. You know, the civil penalties are the penalties assessed against the employer for alleged violations of or cited violations of state wage law and regulations. The wage adjustments are payments to current and former employees as determined by the Department of Labor. The top 5 labor violations, well, you know, our top 10 list that we give out every year, but basically it goes to issues about notification of employees of their pay rate, pay period, fringe benefits, and so on at the time of hire or before any subsequent change. Issues with regard to changing pay records, issues with regard to not paying short breaks, and so on. If you don't have the top 10 list from 2024, just shoot me an email and we'll send that to you. We've posted on LaborNet before too. But the recommendation with regard to the Department of Labor is obviously know the laws here in New Hampshire, know them in other states where you are as well. focus on the onboarding documents, the posters required, your timekeeping requirements. And again, the timekeeping there is the employer is expected to keep accurate time records for all employees for all hours worked. Again, we're talking about hourly employees or salaried non-exempt employees. But who keeps the record? The employee does. So regularly monitoring that to make certain. And if there's a subsequent change, meaning an employee forgets to punch out or punch in or whatever, and there's a change, the change is initialed by the employee. Overtime calculations and what goes into those, and then youth employment violations. I've got a case right now with regard to youth employment violations, and both the state and federal government bend very little on youth employment. Those are protective statutes. Be very careful about the jobs that the youth can work in, ages of 15 to 17, having the parent certificate in place before the youth commences work, the types of work and the hours of work and days of work, being very strict about that. And a lot of employers have different coded name badges for youth, so the supervisors know that they can't work in certain areas or beyond certain hours and so on. And then our friends at the U.S. Department of Labor have conducted over 17,000 compliance actions, and that was interesting. That was down from, and that was in fiscal 24, down from 20,000 in fiscal 23, which again was a catch-up year post-pandemic. Back wages recovered by the U.S. Department of Labor over 200 million. Civil money penalties assessed 39 million. I'm going to pause there. In November of 24, the U.S. Department of Labor came out with a matrix for purposes of determining civil money penalties. Basically, it's a formula based upon the nature of the violations. With that, they've become a bit inflexible or inelastic with regard to how they might abate civil money penalties. They're fixed into a formula. Again, that's November 2024, and we'll see if this new Department of Labor in some way either reverses that or in some way modifies that so it's not so robotic in its response to, because again, each workplace is different, each circumstance is different, and it shouldn't be formulaic, my opinion. But again, you see the number of child labor violations they focus on and the penalties that they've assessed based upon those. So there's no kidding around in that regard. Hot button issues that we're looking at, I think the ones I would talk about would be, again, the youth employment, focusing on limitations, hours limitations and types of work, being very, very, very careful. And now we're coming into a summer season where the workplaces may be hiring kids as youth workers. Just be very careful about the types of work, the hours of work, days of work, and having the parental certificate in place before the kid commences work. In July 1, which is just a few weeks away, which is remarkable, we are looking at a new lactation law in New Hampshire taking effect, which is a bit more stringent than the federal law that went into effect as a part of the Affordable Care Act and the Fair Labor Standards Act. Basically, this applies to workplaces because the federal standard is workplaces with 50 or more employees. This goes to 6 or more employees in New Hampshire. And basically it says that employers in New Hampshire as of July 1 with 6 or more employees need to provide reasonable break times for the nursing mother, and that's within the first year after the birth of the child. Those are 30-minute breaks, unpaid breaks, offered every 3 hours. Breaks may be taken during regular break periods or separately, depending upon the individual needs, not the employer's schedule. This applies to non-exempt employees who will be paid for the lactation breaks that occur during paid breaks. Exempt employees will not experience any reduction in their pay for time spent expressing milk. This must be in a private and secure area with a locking mechanism to protect against intrusion. Not a bathroom. It should be equipped with a comfortable chair, a flat surface for the breast pump, electrical outlet, and nearby access to running water, and reasonably close to the employee's workstation. The employee needing the accommodation should notify HR as early as possible and communicate the particular needs. There's a protection against retaliation, and there are fines and penalties. So what an employer in New Hampshire has to do, again, you've got 6 or more employees, have a policy, post that policy, train your managers and supervisors, and look at timekeeping. And so we're already looking at clients that have produced their lactation accommodation policies. And if you haven't done that yet, that's something you ought to look at in the next 2 weeks for sure. There was some confusion in the last couple of years with regard to New Hampshire's 2-hour reporting law. And the confusion basically really is a result, again, of COVID. Before COVID, less than 6% of the US workforce was working fully remote. At the height or zenith of COVID, 65% of the workforce was working at least on a hybrid basis and some fully remote. We're back down to an average of 30 to 33% remote work. The Department of Labor was looking at its 2-hour reporting law, which again, as you know, if at the request of the employer, an employee comes into the workplace for the employer and there is no work for that person, their option for the employer is to pay the person for 2 hours, which would be accommodating the person for their commute to work and home. The person had an expectation of working more than 2 hours, or putting the person to work and paying them an hourly rate for the work that day. Labor took a position that it applied to remote workers who were taking work home or turning on their laptops or providing some work. So while that remote worker should be paid for time spent for the benefit of the employer, it shouldn't be an automatic 2-hour default. And we had legislation proposed working with the Department of Labor, but there was a legislative snafu in that regard, and that has been tabled. We're trying to, in the last days of this legislative session, trying to resurrect that, but that has been challenging. So it is our understanding that the Department of Labor is revisiting their position without the statutory change, and we're hopeful that they'll come back to what we believe is the original legislative intent for the 2-hour reporting. And then I-9s are being reviewed on a state and federal level. Now, that in part, you could say, is that related to ICE? Is that related to federal executive orders regarding immigration enforcement and so on? Perhaps. But it is also just, it's same as it ever was, that the state and feds look at I-9s to make certain that they are completely filled out, that the supporting information appears genuine on its face, and that, again, federal and state law is complied with. Breaking news, and Karen Whitley is from our employment group is issuing a client alert on this, but basically it's for those employers in Massachusetts that are dealing with that have restrictive covenants, meaning non-solicit covenants. What is the standard for those for purposes of enforcement under Massachusetts law when there's a forfeiture provision built in, meaning if as a part of a separation agreement or otherwise, someone has to forfeit their severance because they breached a non-solicitation provision. Does that violate Massachusetts law? That decision just came out last week. And again, Karen Whitley is going to be producing a client alert on that shortly. What could be on the horizon? I want to go back to one quick thing that I mentioned just a bit ago. I mentioned EEOC. There's been a lot of guidance out there from EEOC. We're seeing a lot more. We're seeing more guidance from EEOC with regard to AI and with regard to AI being used. And Brian Bouchard in our employment law update and several other events over the last several months has been covering the state with regard to AI issues. But one of the issues that the EEOC talked about was using AI for purposes of screening applications and being very careful in that regard because of the potential liability for the employer that relies upon AI in that. But there's other guidance that coming out from EEOC with regard to mental health issues and discrimination, and other issues with regard to everything from updating service animal issues to dealing with sight impaired or hearing impaired individuals and so on. But the most important thing to mention in that regard is in fiscal 24, over almost 90,000 charges of discrimination were filed in the US. Now, that's not an all-time high, but all you need is one. And what we're seeing is a lot more charges of discrimination are being filed on a federal and state level. And with regard to state in New Hampshire, there's a staffing issue with regard to our state, New Hampshire Commission for Human Rights, and hopefully that will be rectified soon. And therefore, things have stalled a little bit with regard to processing of claims. What that can mean is either cases bounce back to the EEOC, or if the case has been with the commission for more than 180 days, the plaintiffs, those representing the individual can pull the case and go to court. So we're hoping that that system gets rectified soon, back on track with regard to staffing and processing of state claims. All will benefit from that. What could be on the horizon? Already in the big, beautiful bill before Congress, and it's now with the Senate trying to reconcile some of the issues. I'm talking about the US Senate with the House version of the big, beautiful budget bill. But there is an issue with regard to, it's a promise that President Trump had during the campaign: no tax on tips, no tax on overtime. Pausing on the overtime issue there, if there's no tax on overtime, how is that going to be handled for purposes of your HRIS system and your payroll withholding system? That is not something that has been addressed yet, and that could cause a little bit of heartburn for employers out there. I think that with regard to compensatory time, that's one that's been kicked around for a while. Compensatory time is paying an hour and a half or providing an hour and a half at straight time for leave time as an alternative to giving someone overtime pay, premium of 50% more than their regular rate. That is only available right now to government employers, and there is at least a proposal that would in Congress that would apply to private sector employers as well. I don't know about that one. There was some momentum on that, but I think that's eroded a bit given to other priorities. Moving the overtime threshold from 40 hours per week to 80 hours per week, I don't think that has a lot of groundswell of support at this point. But here's the thing. What's on the horizon? We're coming to the close of the state legislative calendar. Things are still sitting in Congress, but we're not seeing a lot of movement. I think the most movement you're going to see is with the federal agencies. You're going to see the most movement with federal executive orders and with the courts. And the most important thing is stay tuned, whether through LaborNet, through your local HR group, to SHRM, to the other HR discussion groups and so on. Do stay tuned. This is the close of our New Hampshire Tech Alliance HR Exchange. But we'll be back at this again in September. It's been a very full year. We've covered a lot of topics. What we'll be doing soon is surveying members on LaborNet what topics they would like us to cover in the next calendar year, 2025-26. In the meantime, I think it's fair to say that workplace laws and administrative rules, federal and state, are always evolving. There's no question about that. And the stakes remain high, regardless of who's sitting in the White House, for non-compliance. So the time spent on that compliance efforts will certainly yield dividends and reduce your risk of claims. So let's be careful about that out there. Thank you for your attention today. As always, keep calm and remain cautiously optimistic. I don't see any questions in the feed, but I will say that if there's anything that comes up, anything I've said that you'd like to contact me, you've got my email here, jreedy@sheehan.com. I'm happy to follow up with you. In the meantime, here are the credits that I referenced at the outset. Liz Tezik will be sending you a copy of the materials, as well as a recording and this HR credit. But thank you for your attention. And oh, there was one quick question I just saw as we're closing out. Should we have a form for requesting lactation breaks? I think that really it's just talking to working with the manager or supervisor that just working out the breaks. It should be that flexible. So I hope that this very quick update, a year in review, has been helpful. And I hope you have a good rest of the day. Thanks so much.